Hi friends, Steve Welty, broker CEO of Good Life Property Management, here to break down and simplify the very complex AB 3088, the new law out of Sacramento to help protect tenants that are experiencing a hardship due to COVID-19. So disclaimer, I'm a real estate broker and property management company owner, not an attorney, so please check with your legal counsel on all of this. This is just intended to be general information, try to help you simplify some of this really complex stuff. So basically, AB 3088 limits the landlord's ability to evict a tenant that has rent due from March 1st, 2020 to January 31st, 2021, if the tenant has experienced a financial hardship due to COVID-19. So how does it work? So basically, the first thing it does is it breaks the rent due into two different periods. Let's deal with the protected time period first, from March 1st to August 31st. So if your tenant's been financially hurt by COVID and signs a declaration and returns it to you, they cannot be evicted. And your debtor becomes consumer debt, and the landlord can sue for a judgment for that debt starting on March 1st, 2021. And under the protected time period, if the tenant doesn't pay rent, you have to serve a disclosure that lets them know of their rights under the new law. In addition to that disclosure, you serve a 15-day notice, but this is a new notice that you'll have to get from an attorney or from your property management company. And there's a couple different notices. There's a notice if your property falls under the CARES Act, which is if it's like a federally backed mortgage or if you accept Section 8, things like that. And then there's a different notice if it doesn't fall under the CARES Act. So if it falls under the CARES Act, it's a 30-day notice you serve that's pay rent or quit. So instead of the normal 3, it's 30 days. And if it's not CARES Act, you can serve a 15-day notice. So along with your notice to pay, there's a disclosure that tells them about their rights. And then there's also a declaration, a blank declaration that the tenant would need to fill out and sign and return to you. Now, if it's rent they owe you after September 1st, so September 1st through January 31st, then that's known as the transition period, and they are required to pay at least 25% of the rent by January 31st. So ideally they would pay that at least monthly, but per the law, they could pay it just in one lump sum a day before, or I guess by January 31st, 2020. And same thing applies. You must sue in small claims court for that remaining balance of 75% owed. The eviction courts won't hear it. And that's for tenants that return in that signed declaration. So the other big part of this is now it makes remember the other law that passed not so long ago, AB 1482, that was very complicated as well. That had to do with just cause eviction and landlord protection. This was pre-COVID. So that didn't apply to houses, condos, it had exclusions for like your mom and pa landlord. Not anymore. So now under the new AB 3088, there's just cause eviction protections basically for everyone. Now I guess there's some gray areas, so check with your attorney. But what this basically means to you is you have to be very careful even when now just giving your tenant notice to not renew their lease. There has to be specific reasons. There's only like a handful of allotted reasons that you can give the tenant notice to terminate their lease now. So read our blog on AB 1482. We'll put a link in the notes below so you can find out more about just cause and what that means. But basically, it applies to all tenancies, and so you have to be very careful. You can't just not renew. So also be advised, pay rent or quit notices, they've been extended. Talked about that a little bit earlier in the video, from 3 days to 15 days or 30 days for properties under the CARES Act. And to make this all more confusing, if your local municipality has an eviction moratorium in place already that's more strict, then that local law will prevail. Man, this is a lot. So, closing. What do I do if my tenant didn't pay rent? Number one, you've got to call an attorney, or you have to call a property management company to help. This is too complex. The penalties are too stiff. We're talking about $100,000 in some cases for violating the CARES Act. You don't have the forms, you don't have the expertise. You need to call a professional, either an attorney or a property manager. Now, assuming you want to proceed on your own, here's some general steps. Number one, check your local municipality and see if they have a local eviction moratorium that's still in place that might prevent you from doing things under the new AB 3088. See if your property falls under the CARES Act. talk to your bank and see if it's federally insured. Mortgage is one of the qualifiers. 3, see if your tenant qualifies as high income. I didn't even get into that, but if your tenant qualifies as high income, there's some additional disclosures you could have to do. But you need to make a decision if you want to tread in those waters. 4 is serve the proper disclosure to your tenant. This is due by September 30th. So any late payers to your properties, make sure you serve that disclosure to them. And after that, you just wait. If your tenant's willing to pay some money, most tenants are going to want to stay current. They don't want bad debt. They don't want to get sued in small claims court. But you're just going to have to wait if the tenant's not paying to recover or try to recover those amounts. But hopefully most tenants will try to pay the most that they can to make everyone, because we're all in this together, right? So if you have any questions, please email me, steve@goodlifemgmt.com. I'll put it below, or call our office, 858-207-4595. Make it a great day.